Swayam Prabha. Digital India. Educated India.
Welcome dear students. Today we discuss the last topic of this course, role of SEBI as a regulator of the capital market. I am Dr. Jaswant Saini, Associate Professor, Faculty of Law, Maharshi Dhyan University, Rohtak, present this topic before you, and as usual we start each and every topic with the learning outcomes. What we learn from this entire discussion. First one is understand SEBI's establishment in 1992, evolving from a non-statutory body to a statutory body. And SEBI is a regulator of capital market, and SEBI issue the direction, guidelines for capital market, and SEBI established for purpose of replacing the controller of capital issues. Second one, to learn about SEBI's legal characteristics, including perpetual succession, common seal, property related powers, and ability to contract and litigate. Third one, to understand about SEBI's objective as outlined in the preamble of SEBI Act 1992, focusing on investors' protection, market development and regulation. These are the main objectives of SEBI board. To learn about the specific power of SEBI, such as the ability to suspend trading, restrain market access, conduct inspections, and enforce compliance through penalties. These learning outcomes settle the goal of this entire discussion, and one by one we touch the various aspects of establishment of SEBI and their working. Characteristics of the company. SEBI is considered as board. SEBI is a statutory authority, and SEBI is established as a corporate body. And all those characteristics which are available to a corporate body, these all characteristics are available to the SEBI also. Being a body corporate, SEBI exercise very first characteristics, that's perpetual succession. Perpetual succession indicate that once a body established, that's survive forever, and members comes or out, there is no any effect on the functioning of this body. Like company, SEBI act as a corporate body. Perpetual succession indicate that from generation to generation, this institution working as they established in the first day. And second important characteristics available to the SEBI board as a corporate body, this SEBI represent through its common seal, means where we found any document with the stamp of SEBI board, we presume that this is the original document authentication of the document with the seal. Seal indicate the stamp, and after 2015, if matter related to attorneys, in such cases, seal is not an essential element, and without the seal of the SEBI board, the document also treated as the authentic document. And common seal is the requirement in earlier stage, but after 2015, that is not an essential condition. It means some documents we entertain without even the common seal of the SEBI board. And another important characteristics available to the SEBI board, SEBI acquire the property, hold the property, and dispose of the property, both type of properties, movable and immovable, on their own name. The major thing attached with the property, you may be owner of the property, but sometimes you are not allowed to be disposed of the property. Both type of rights we required related to property. You hold the property, you enjoy the property and you dispose of the property, and movable, immovable, both type of properties available to the SEBI, and they hold on their own name and they dispose of the property as per requirement. And another characteristics available to the SEBI, being a body corporate, SEBI enter into any contract on its own name. It means SEBI established for all purposes and SEBI represent by its own name. We discuss the characteristics of the SEBI. All characteristics available to the SEBI board is available, and the third characteristics available to the SEBI acquire, hold and dispose of the property. Both type of properties, movable and immovable, SEBI acquire on its own name and SEBI enjoy the property and SEBI allowed to be disposed of the property. This is the important aspect here. Sometimes we are entitled for this property and we enjoy the property, but we are not allowed to be disposed of the property, being a beneficial owner of this property. But if this right attached with this one, it means you have absolute right related with the property, and SEBI enjoy both rights here, acquire the property and dispose of the property from its own name. And both type of properties allowed to be SEBI, movable and immovable. And another characteristics available to the SEBI, that SEBI enter into any agreement with the stipulated condition which applicable on the contracts. So, contract must be related with the duties of the SEBI, contract must be related with the object of the SEBI, and SEBI enter into contract on its own name. There is not on the behalf of any other, SEBI enter into the contract on its own name or for on his own behalf. So, that is the important thing, no need to be take the name of others. SEBI is a person in the eyes of law, so the artificial persons also allowed to be enter into the contract on its own name. And another characteristics available to the SEBI file a case against anyone and others also file a case against the SEBI. Sue and be sued. This is the important characteristics available to the corporate bodies, and SEBI is considered as a corporate body for all purposes. And SEBI also represent through its own name. This is the important thing here. Enter into contract in his own name and SEBI represent by its own name. It means the letterhead used by SEBI and other agreements or other contracts related to the SEBI powers, SEBI adjudications or SEBI representation, they use their own name. So, this is the important characteristics available to the SEBI, being a body corporate. SEBI established in the year of 1988 first time through Parliament ordinance. Basically, SEBI established in 1988 a budget speech delivered by P. Chidambaram, and they emphasized that there should be a regulator. Security Exchange Board of India established through ordinance in 1988, and after this one in 1992 by a SEBI Act, that body became a statutory body. Securities and Exchange Board of India established on April 12, 1992 in accordance with the provisions of the Securities and Exchange Board of India Act 1992. The Security and Exchange Board of India first established in 1988 as a non-statutory body for regulating the securities market. Basic purpose of establishment of this body, at that time they emphasize the central government insists that there should be a separate regulator of a capital market. Central government look after all the issues related to capital market prior to establishment of this body. But in 1988 they feel there should be a separate body who look after the matters related to securities, and they gave the statutory status to this body in the year of 1992. Before it come into existence, the entire issues deal by controller of capital issue. That's the ultimate authority who deals with the regulatory authority in such area and derived power from the Capital Issue Control Act 1947. Before this SEBI Act 1992, we govern by Capital Issues Control Act 1947, and in this act central government is the ultimate authority and no any specific powers hand over to any other authority to deals with the securities matter. So basically, as a student of business, as a student of law, we start with the preamble of every act. Preamble is that part of the act which settle the goal, which settle the object of the particular act. And every act designed with some purpose. And our judiciary, high courts and Supreme Court basically perform the function of interpretation. And any case when coming before the Supreme Court or High Court related to interpretation of any act, they first start with the preamble. Because preamble define what's the main aim, what's the object, what's the motto to introduce this enactment. So preamble of SEBI Act basically decide the goal. SEBI board established with some functions, and the functions here to protect the interest of investors in securities. Very first function here decide in this preamble. Second, promote the development of and to regulate. Promote, development and regulate, they are the four different areas defined in the preamble where in the securities market and matters connected therewith or incidental thereto. So we divide this preamble into 7 parts and we develop our understanding about this one regarding objects of the SEBI, why central government established this specific agency to deal such matters. Very first here, to protect the interest of investors. It means every type of interest of the investors here protected by SEBI, either related to personal, either related to corporate body. So every type of interest must consider under this board, or board consider every type of interest for the betterment of market, for the betterment of investors. So investor is the main concern and their interest also look after by this board. Where there we protect the interest in securities. If matter related to any other nature other than securities, those matters not covered by this law, not deals by this particular agency, this SEBI board. Promote and development, that the another aspect here, the functions are designed to promote. Promotion is the important thing. You promote the interest and you safeguard the interest and you act in the line of development. It means new things you may be introduced under this head of development. Development indicate that according to circumstances you may be changed. According to circumstances, if you change, that consider as development. For the development of whom? For the development of market, for the development of interest of investors, you act. And to regulate, regulate word define that you frame the rules and regulation. This word indicate that rules and regulation frame by the SEBI board related to security market, related to protection of investors. So regulate word basically indicate that SEBI board is authorized to frame the rules, regulation and they implement this one. Only not framing purpose they establish the SEBI, they also define, they implement these rules and regulation. And where these rules and regulations are applicable, these rules and regulation related to security market, not for any other market like your fish market, grain market or any other market or grocery market, those markets not in here discussion. We only discuss here that market which related to securities. And securities defined in Security Contract Regulation Act 1956 and all instruments who settled as a claim or assets, financial assets, those cover under the definition of securities. And another thing is here on the part of SEBI, any other matter related to the securities means matter connected with the same. If matter not directly connected or indirectly connected, those matters also deal by SEBI. Related matter, connected matters, similar matter or like matters, these all matters deal by SEBI if matter relates to security market or incidentally they touch the area of the securities, even then those all matters deal by SEBI, and this is a wide power given to the SEBI through this preamble. Preamble of the act decide the goal or the powers of this statutory body. So, what is the composition of SEBI board? We try to understand with this chart. Very first here there should be a chairman, a person or head of this institution known as chairman, and representative of Ministry of Finance also one person who represent the entire ministry here. SEBI is a statutory board and the guidelines or the direction issued by the SEBI board applicable as a law in security market. So, we required here a huge combination of various segments here. Central government run the entire functioning related to finance through finance ministry. So, representative of finance ministry is here, chairman is also an expert person who have a special knowledge in the field of securities, in the field of law, in the field of administration or in the field of business. So, chairman always a specific person who have a special knowledge or expertise in particular fields. So, representative of Ministry of Finance is also here and representative of Ministry of Corporate Affairs. Basically, Ministry of Corporate Affairs established in 2004. Prior to this one, this ministry was considered as one of the Department of Finance Ministry. 27th May 2004, this ministry specifically separate from this finance department, and this ministry established to deal with the matters related to corporate affairs, and SEBI is also related with the corporate affairs. So, we depute here one representative of Ministry of Corporate Affairs, and that is the discretion of the government to whom they hand over this power or to whom they depute here as a member of the SEBI board. And a representative of Reserve Bank of India, that is also here one of the member in this SEBI board, that is the composition demands that representative of Reserve Bank of India. Reserve Bank of India is responsible for the monetary policies in India, and that is the ultimate authority or exercise the monopoly in the coin and currency, and issuing of note by the central government with the consultation of RBI, and RBI is the specific body designed to deals with the monetary policy as well as deals with the coin and currency. So, one of the representative of Reserve Bank of India also working as member in the SEBI board, and 5 other members we required here. Out of these 5, 3 shall be the whole time member. Whole time members means they particularly deals these activities and they not deal any other activities. Specifically, they are deputed for the purpose of security market, and these all members here appointed by central government with the consultation of concerned ministry. So, this is the composition of Security Exchange Board of India, which known as SEBI, and SEBI is deal the security market incidents as well as regulate, promote and protect the interest of investors. So, management of the SEBI board consists with following way. Chairman is the topmost body or topmost person who represent the entire SEBI board, and some other members also here, representative of ministries, representative of RBI and central government representatives. Journal functions and powers of the SEBI board defined in section 11 of SEBI Act 1992. And this is the important section in this act, and section 11 define power to inspect books of account. So the question is here, books of accounts of whom? Very first, all companies here obtain the certificate of incorporation from Registrar of Companies, and Registrar of Companies also under the supervision of SEBI board working. So all companies automatically comes under the purview of SEBI functionings. So inspect book of account of whom? All companies, all intermediaries. Intermediaries means all such agencies which are related with the companies, related with the consumers in any way. Intermediaries are such persons who act as a link between two agencies, one who have the money and second who required the money. One who have the money, second who required the money, industries required the money. In between these two agencies, those who act as a bridge, they are known as intermediaries. And all intermediaries here under the control of SEBI, because SEBI issue the certificate to these intermediaries, and without the license issued by SEBI, they are not allowed to be act as intermediaries in financial market. So companies, intermediaries and banks also cover under the meaning of intermediaries, and financial institutions also cover under the meaning of intermediaries, or your depositories also include in the meaning of intermediaries. So under this section 11, SEBI inspect books of account of any agency which related with the security market, which related to the capital market, which related to the stock exchanges. Stock exchanges also cover under the control of SEBI. So any agency, any institution, any body corporate which related with the market in any way, they are under the control of SEBI, and under this section 11, SEBI authorized to inspect books of account. And you know it's very well, books of account always maintained by the institution, company or body corporate itself, and audit always performed by independent agency, independent persons, that chartered accountants. So that is a very important power in the hands of SEBI, and under this power SEBI make code in the form of accounts which maintained by the company. So inspecting powers is the important power which establish that's you exercise as a regulator of the capital market. So another power of the SEBI exercise all powers of civil court, and power of civil court basically we consider one is here evidence on oath. If any body allowed to be take evidence on oath, it means that's exercise the power of court. And power of summon, if you call to anyone and he is bound to be present before you according to the terms and condition of summon, it means you exercise the power of court. And third important, compel the attendance, compel the presence. If you are authorized to compel the presence, it means you exercise the power of court. And fourth and important power in the hands of court, they punish for their own contempt. And fifth one is here, if you not follow the rules and regulation, the punishment may be provided by the court, by the agency. If these powers exercised by anybody, we consider they exercise the power of court. And these all powers in the hands of SEBI available, and SEBI exercise the power of courts under section 11. And section 11 further deals with the power to regulate security market and intermediaries. The question coming before us, being a student of business and law, we held that regulate word basically relates to act, statute, ordinance, rules, regulations, bylaws. These all things indicate that some certain set rules are here which decide that you bound to follow the same. India runs under the scheme of analytical school, and jurisprudence define that law framed by political superior and law applicable on political inferior. Those agencies which are authorized to frame the rules, regulation, it means they are superior. So, SEBI board is here authorized to frame the rules and regulation. For whom? The question arises here, for whom they frame the rules and regulation? They frame the rules and regulation in the light of preamble. Preamble defined for security market. And if we enlarge this word security market, it means stock exchanges include here, intermediaries include here, and financial institutions include here, and companies are include here. So, power to regulate security market, and security market indicate that any agency which relates to the stock and shares, where there is a dealing of stock and shares. Intermediaries are such persons who maintain the licensing between those who have the money and who require the money. So, power to regulate security market or intermediaries in the hands of SEBI, and SEBI issue the license to intermediaries under section 12 of the SEBI Act 1992, and without the license no one supposed to be act as an intermediaries in the security market. And in this direction, SEBI regulate to prohibit issue of prospectus, offer document, advertisement. It means this prospectus which required to invite the investors for invest their hard savings in any business, any company, then this prospectus also comes under the purview of SEBI board. SEBI settled some certain set rules. If you fulfill these rules, no need to be take permission from any agency, even then SEBI board. You may publish your own prospectus. You invite the public for investment point of view. So, power to issue direction. Direction for whom? Direction for development and regulation of security market. For this particular purpose, SEBI is allowed to issue the directions, or you may be say guidelines. And these guidelines and directions are mandatory or not, this is the important question, and sometime some areas here deals with this question here. Directions and guidelines which issue by a statutory body, that always bound, it means mandatory on the entire jurisdiction where there is a regulation applicable of this regulator. So, functions and power of SEBI board defined in section 11, and that is the duty of the SEBI board to protect the interest of investors, and where in security market. And this SEBI is also deals with the stock exchanges, because stock exchange is basically the market where we deal the securities, selling and buying of the securities, and stock exchanges are the facilitators who provide the facility to deals with the security market or to deals with the securities which cover under the definition of securities. So, registration and regulation and working of all intermediaries, either they are stockbroker, sub-broker, share transfer agent, this particular instances here highlighted, this particular words here highlighted, every type of intermediaries, either they relates to capital market or money market, they first need to be obtain the license from SEBI. Either you act as underwriter, either you act as an financial portfolio manager, merchant banker, underwriters, all type of intermediaries first take license from SEBI under section 12. Registering and regulating the working of depositories. Depositories in India, two depositories here, NDSL and CDSL, they are also working as a intermediaries and they need to be obtain the license from SEBI. And in 1996, when Depository Act 1996 introduced, after that in our India two depositories established. and foreign institutional investors and credit rating agencies and such other intermediaries which related with the SEBI, they first need to be obtained the license from the SEBI, and registration and regulating working of different schemes, collective investment schemes, venture funds and other mutual fund schemes, they need to be first take approval from the SEBI. So, functions and powers of the SEBI board. SEBI also prohibiting fraudulent and unfair trade practices. If any practice is unfair and fraudulent, those practices restricted by SEBI, and SEBI look after those activities of the corporate bodies which against the public policy. And SEBI also deals with the promotion of investor education and training of intermediaries of security market. Promotion word defined here in the form of education and training. How you promote the protection of investors through these trainings, through this education you promote, you protect the interest of investors. And another power in the hands of SEBI, that is the very important here, prohibiting insider trading in securities. Insider trading indicate that on the basis of unpublished price sensitive information, if someone gain or avoid the loss, those activities known as insider trading, and SEBI is here authorized to restrict this insider trading. And SEBI regulates substantial acquisition of shares. Major issue in this market is here, one company maybe try to hold the other company's control, and in this direction they buy the shares more and more of such company to acquire the control. So, substantial acquisition of shares and takeover of companies under the control of SEBI. SEBI look after such matters which related to the same. And SEBI also call any information or inspection conducting inquiries and audits of stock exchanges, mutual funds and other person associated with the security market, or intermediaries or self-regulatory organization related with the security market. So, no doubt we know that every agency which related to the securities market, they all cover under the purview of SEBI, they all under the functioning of SEBI. So, SEBI control all such functionings which related to security market. Functions and power of SEBI board, call any information or record from any person or any agency which relates to security market, either that deals by central government or the state government act. So, that is immaterial, either they govern by state government act or the central government act, they directly or indirectly comes under the purview of SEBI board, and they conduct the relevant investigation and inquiry for the purpose of justice. SEBI is here higher authority in the field of security market to frame the rules and to implement the rules. And for this particular purpose, if required any investigation or inquiry, then that is allowed on the part of SEBI. SEBI is fully authorized in this direction. And they call any information from any authority, either the authority in India or outside the India, having functions similar to those of the board, the matter related to the prevention or detention or violation in respect of securities laws. If any matter related to securities laws, violation or implementation, the authority related to India or outside the India, from those authorities SEBI may call any information and deals the matter as per the law of the country, and as per the requirement of situation they may deal the matters. And for this particular purpose, if any agreement required, SEBI may enter into any agreement for this particular purpose. If either within India or outside India, SEBI may introduce any arrangement or agreement for this particular purpose. Understanding with such authority with the prior approval of the central government. But one restriction, one rider is applicable here. You need to be first take approval from the central government if you deals in international matters. So that is the only requirement here, not any other thing here. Performing such function and exercising such powers under the provisions of SEBI Act 1992 or Security Contract Regulation Act 1956 as may be delegated to the board. And in this direction, SEBI may levy any fee or other charges for carrying out purpose of this act. For the purpose of SEBI Act and for the purpose of Securities Contract Regulation Act 1956, SEBI may impose any penalty or maybe impose any fee for proper registration and functioning of all issues related to security market. And some other functions also here related with the SEBI. Suspend the trading of any security in a recognized stock exchange. If any time any complaint before the SEBI available regarding corrupt practices or involvement of any body corporate in corrupt practices, SEBI after conduct the inquiry and follow the rule of natural justice, suspend the trading of any security from the recognized stock exchange. And in this direction, SEBI also restrain any person from assessing the security market and prohibit any person associated with security market to buy, sell or deal in security. So basically that's the ultimate power. SEBI may restrict the company also, SEBI may restrict the individual also for deal in security market. And security market officers or any officers which relates to stock exchanges or any office bearer of stock exchanges or any intermediaries, these officers also under the control of SEBI. And SEBI under this special power may suspend any office bearer of any stock exchange or self-regulatory organization from holding such position. If you are the director of any company, if you are the director of stock exchange or you may be in any capacity, you may be covered under the control of SEBI board and SEBI board may suspend to any office bearer of the stock exchange or any depository, CRA or any agency which cover under the control of SEBI board. Impound and retain the proceeds of security in respect of any transaction, and for this particular purpose approval of the judicial magistrate of first class having jurisdiction, that's also deals here. Any investigation conducted by SEBI that required to seize any record, in such cases SEBI need to be first take approval from the judicial magistrate of first class in whose jurisdiction the office of the particular company or agency is situated. So license issued by SEBI under section 12 to various agencies, various intermediaries, that's the whose list here. We discuss custodian of securities also here, depositories, investment advisor, stockbroker, sub-broker, share transfer agent, bankers of an issue, merchant banker, underwriters, portfolio manager, trustees of debenture trust deed, registrar of to the issue, mutual funds. Presently in our India 43 mutual funds are working and the huge amount in the control of mutual funds. Mutual funds are such funds where pool the money and invest in security market and they arrange the money after sale of units. CIS, collective investment scheme, venture capital fund scheme, credit rating agencies, foreign institutional investors and custodian of the securities. When we are interested in the GDR, ADR and IDR, then we need to be appointed the custodian of the securities. So the wide range is available here to deal with the intermediaries here. Then under section 12, the power given to the SEBI board to issue the license of the intermediaries and control of the intermediaries in the hands of SEBI board. Section 12 of capital SEBI board deals with the capital market intermediaries and these intermediaries are not allowed to act in the market without the approval of SEBI, without the license issued by the SEBI. So, some offences and penalties here define, which establish that SEBI exercise the power of court also. And these offences and penalties we discuss here one by one. Section 15A of the SEBI Act 1992 define offence. Offence, it means if any direction, guideline issued by SEBI and someone not follow, he commit an offence. If any activity declare as an offence, that's a illegal act, that's unlawful act, and someone found involved in these activities, they are liable to pay the penalty, either the civil or criminal. That's a different thing here. If on the demand anyone fails to furnish any document, return or report to the SEBI board, he shall be liable and he commit an offence. If fail to file any return or furnish any information, books or other document within time, it means within stipulated period, if you fail to submit these documents, it means you commit an offence. And fails to maintain book of accounts or record specified therein regulation, even then you commit an offence. And what penalties here define for these offences? It means you not respond against the guidelines of SEBI. Penalties here define 1 lakh rupees, but which may extend to 1 lakh rupees for each day. The question is here, if penalty basis on each day, it means we consider the offence is continuing offence, and penalty is here continuing penalty. So, this penalty is a huge penalty, 1 lakh rupees per day, and on the discretion of the board, the penalty may be increased 1 lakh rupees per day. In one instance 1 lakh rupees, and that's may be increased up to 1 lakh per day, and the maximum limit is here defined 1 crore rupees. This is the power of the SEBI board to impose the penalty if someone not follow the direction of the SEBI or not provide the information as required by the SEBI on call. If SEBI call the information, you are bound to be supply the information at the earliest or within time period, otherwise your acts treated as offence. Section 15B of the SEBI Act 1992 define this offence also. If any person who is registered as an intermediary, this particular section related to intermediaries. If any person who is registered as an intermediary and is required under this act or any rules or regulation made thereunder to enter into agreement with his client, fails to enter such agreement, he shall be liable. Question is here, every intermediary is here required to be enter into agreement with the every client regarding their dealings. If you fail to establish the relation with the clients through this agreement, and if someone reported this act, unless and until acts are reported, they are not treated as offence. So, if someone reported this act, that deems to be an offence. And once a offence, any activity declared as an offence in the eyes of law, then law deals with the same as a penalty, either criminal penalty or civil penalty, that is the different thing here. But if any offence declared by law, that should be resolved with some penalties. Unless and until we provide the penalty, there is no any meaning of declaring of offence. So, penalty here define which shall be not less than 1 lakh rupees. 1 lakh rupees is minimum, but which may extend to 1 lakh rupees for each day. I again highlight here this thing, if penalty available in the form of each day, it means that indicate that offence is continuing offence and penalty is recurrent penalty. It means day by day penalty increase and your offence comes to an end when you fulfill the requirement of penalty, and which such failure continues subject to a maximum of 1 crore rupees, and penalty up to the extent of 1 crore rupees may be applicable. That is the highest amount of penalty here applicable and imposed by SEBI under section 15B. Section 15C also deals with some penalty and offences here. Offences here, if any listed company or any person who is registered as an intermediary after having been called upon by the board in writing. So, question is here, there is no any meaning of verbal things in law. Law always insists the written requirement, written document. And if any complaint coming before the SEBI and SEBI asks to any registered listed company or any registered intermediaries and they fail to redress the grievances of the investors, fail to redress such grievances within time specified by the board. Question is here, first complaint coming before the board and board issue the direction in written, and even after this direction someone failed to comply the direction and someone not follow the guidelines issued by SEBI and fail to redress the grievances. In such cases penalty is available. Penalty how much? The same penalty 1 lakh rupees, with that extent to 1 lakh rupees for each day, and the maximum penalty is here 1 crore rupees. So, the main important point is here, our regulators are so serious about these things which related to protection of investors. Section 15D of SEBI Act 1992 also deals with the offence matter related to mutual funds. If any matter related to mutual fund and act without obtaining certificate of registration, failure to comply terms and condition of certificate, failure to listed in security market, failure to dispatch the certificate of units, fail to refund the application money and fail to invest money collected by such collective investment scheme or mutual fund in the manner stipulated period within time period, then penalty is 1 lakh rupees for each day, and that amounts to maximum 1 crore rupees. The point is here, regulator is so serious relates to any default. 15E also deals with the offence and penalty, where any asset management company, mutual fund always appoint a asset management company, and this company is a public limited company who introduce the schemes and manage the funds of mutual funds, and penalties here 1 lakh rupees, but which may extend to 1 lakh rupees per day and 1 crore rupees maximum. This is the important again in relation to mutual funds or in relation to asset management company, you are supposed to be act in transparent manner. Section 15F also related to offence matter related to stockbrokers. The offence failed to issue contract note. It means in any way, if you not deal properly with your clients, it means you commit an offence, and this offence is here, penalties here not exceeding 5 times the amount for which the contract note was required to be issued, and 1 lakh rupees for each day and maximum 1 crore rupee whichever is less, and 5 times of excess charge whichever is higher. So, this is the penalty here provided in the form of section 15F. 15G relates to insider trading, and the important point is here in this case the how much penalty is important for insider trading, and I already highlight here insider trading means on the basis of unpublished price sensitive information, if someone gain or avoid the loss, it means that activity is known as insider trading. Penalties here not less than 10 lakh rupees, but which may extend to 25 crore rupees. That is the highest penalty in our India which imposed by any statutory body. or 3 times of the amount of profit made out or insider trading, whichever is higher. So, this is the highest penalty applicable in this particular section under this act. 15H also related with the penalty for non-disclosure of acquisition of shares and takeover, and the penalties here 10 lakh rupees, but which may extend to 25 crore rupees, and 3 times of the amount of the profit made out of such failure, whichever is higher. So, this is the important penalties. Section 15HA, that is also related with the offence of any person, either individual, either a corporate body, either artificial person, indulging in fraudulent and unfair trade practices relating to securities, he shall be liable, and the penalty defined here not less than 5 lakh rupees, which may extend to 25 crore rupees. So, in case of penalties, the huge penalties imposed if anyone use the corrupt practices. 15HB also relates with the penalty, and offence is here if any rules or regulation made, direction issued by board therein, and which no separate penalty has been provided, shall be dealt by this section. If no any specific penalty is provided, then deal by this section, and section define 1 lakh rupees, which may extend to 1 crore rupees. If particular section define the penalty, then the different rules are applicable. If no any penalty defined in the act for any activity, those cover under section 15HB. Fines are primarily associated with legal and regulatory enforcement, focusing on the punishment of offences committed against public welfare. Penalties is a broader term and can extend beyond legal and regulatory enforcement. So, that is the differentiation here, fines and penalties here, and basic idea behind the same, everyone follow the guidelines or direction issued by SEBI, being a statutory body, being a regulators. If someone not follow, it means that is commit an offence. And section 15K of the SEBI Act 1992 empower this board to establish a Securities Appellate Tribunal, and this is the highest authority who deals with the matter of securities. Central government by notification establish one or more appellate tribunal. This tribunal known as Securities Appellate Tribunal, and they exercise the jurisdiction, power and authority conferred on such tribunal as time to time. It means central government through gazette notification has set up a Securities Appellate Tribunal. And what factors to be taken into account by adjudicating officers when they impose the penalty? Quantum of penalty must be keep in mind before impose any penalty, and amount of disproportionate gain or unfair advantages. How much amount involved and how much penalty. The amount of loss, that is also consider before impose any penalty, and repetitive nature of the default. If a person commit again and again these defaults, then different penalties are applicable. If he commit first time this offence, then different penalty may be imposed. And now we are summary part here of this discussion. SEBI play a important role in safeguarding the interest of investors in security market. And secondly, broad functions given to the SEBI to regulate the entire market or any matter related with the security market, they cover under the purview of SEBI. And third one, SEBI directions applicable as a mandatory conditions, and that is the compulsion on those against whom issue the direction, otherwise your acts treated as an offence. SEBI main aim settled by the preamble of this act, protect investors' interest in the security market. This is the important task given to the SEBI. Thank you.
Hello, I am Professor A.K. Sharma and I teach sociology in IIT Kanpur. I am taking up a question, what is world population crisis? World population crisis refers to explosive growth of population which occurred during 1950s and 1960s. For millions of years, some people estimate that perhaps man appeared on this planet Earth 5 lakhs years ago. It took these 5 lakhs years for world population to reach first billion in 1820 AD. And that means that the population in ancient times must have been rising at rate 0.000 something percent per year. Now, in 1950s and 1960s in the world, you find that population started growing at rate more than 2% per year. This is what is meant by population crisis. You can imagine that if a population grows or anything grows at 2% per year, then in about 35 years time it can double. And obviously, particularly in the context of less developed countries, it had implications for poverty removal, for employment generation, for maintaining health, improving life expectancy, raising educational levels, etc., etc. The reason behind this population crisis was improvement in life expectancy or improvement in general health standards of populations. You may not be knowing, or you will be surprised to know that about 100 years ago in our country, life expectancy means average age of death or average age of life, whatever you say, of a newly born child was only 20 years, and today it has reached the level of 68 years. Much of this improvement in less developed countries occurred in 1950s and 60s, and therefore, with improvement in health, improvement in life expectancy or average age of birth, average age of death, and population started growing at explosive rates, and people started writing about this. This is population explosion, or this is population crisis. And now one can say that the period of peak growth rate is over, and from 1971 onwards in the world as well as in our country, growth rate of population has started declining. Now, in India you may like to know what is the current growth rate of India's population. Currently India's population is growing at 1.5% per year, and the reason is that after sudden or unexpected improvement in health conditions in 50s and 60s, which led to population crisis, we find that today average number of children has also started coming down. So, there was a time when average number of children per woman was around 11 or 12, now it has come down to 2.5, and therefore, the growth rate of India's population has come down to 1.5%, and we can hope that in the future, means in the coming decades, even if nothing changes on the front of fertility or number of children, India's growth rate of population will decrease further and eventually come to a zero level, as said by the 11th 5-year plan of India. And now the major cause of high growth rate of population is not high fertility, but the age distribution of population. So, we have a high percentage of population at the younger ages, and that is the cause of high rate of growth of population. Eventually, when population of India will also age like population of other developed countries, our growth rate will start falling. Thank you. Now, we will meet in the future.